On April the 10th, 2026, Elon Musk's artificial intelligence company xAI filed a federal lawsuit in Denver. The target, Colorado's Senate Bill 205, the first comprehensive state-level AI law in the United States. The law is set to take effect on June the 30th. xAI wants it blocked before it does. SB 205 was signed by Governor Jared Polis in May 2024. It imposes disclosure and risk mitigation requirements on developers of high-risk AI systems, those used in decisions about employment, housing, education, healthcare, and financial services. The aim is to prevent what the law calls algorithmic discrimination. It was, by design, the first law of its kind in the country. xAI's complaint makes two core constitutional arguments. First, that the law is unconstitutionally vague and invites arbitrary enforcement because it fails to define key terms. Second, and more provocatively, that SB 205 violates the First Amendment. The complaint states the law would force Grok to abandon its disinterested pursuit of truth and instead promote the state's ideological views on various matters, racial justice in particular. It's a bold framing, and it raises an immediate tension. According to The Guardian, Grok has been plagued with accusations of discrimination, reportedly producing racist, sexist, and anti-Semitic content, spreading conspiracies about white genocide, and in one instance referring to itself as Mecca Hitler. A chatbot with that track record claiming to pursue disinterested truth invites scrutiny. What makes this lawsuit more complex is that xAI is not the only party with doubts about SB 205. Governor Polis himself issued a signing statement expressing reservations about the law's potential to tamper innovation. 6 prominent Colorado Democrats, including U.S. Senator Michael Bennet and the state's Attorney General, pressured the legislature to delay the law's original effective date. A working group convened by Polis announced a policy framework for revisions last month, but formal legislation to amend the law has not yet been introduced. The federal government has stepped in as well. In December, President Trump signed an executive order that singled out Colorado's AI law by name, calling it cumbersome. The order directed the Secretary of Commerce to review state AI laws and restrict federal broadband funding to states with what it termed onerous regulations. Then in March, the Trump administration released a national AI policy framework that explicitly calls for prohibiting laws that coerce AI models to ban, compel, or alter content based on partisan or ideological agendas. The language in xAI's complaint echoes this framework closely. Colorado's Attorney General has declined to comment on the litigation. California's Attorney General, meanwhile, has warned against relying solely on Congress for AI regulation, pointing to years of delays on data privacy and technology laws. This case now sits at the center of a deeper question: whether individual states can regulate AI within their borders, or whether the industry, backed by federal policy, can prevent a patchwork of state-level rules from forming at all. The answer from a federal court in Denver may shape AI governance across the country for years to come.